Buying a property is a massive decision, especially if you're buying overseas in a country like France. People don't understand the legal process and the intricacies of the buying process. So today we're joined by an expert notaire, bilingual, who has been in the industry for over 20 years. He's going to be answering common questions like what the notaire's role is along the French buying process, the difference between off-plan and new build purchases, what happens if a mortgage gets refused, common mistakes that people make to avoid, and how deposits and cooling off periods work. So if you're buying a property in 2026 in France, then stay tuned because this video is for you.
Yeah, so my name is Simon. I'm a notaire based in Moutier in the Savoie, in the Alps. I've been here since about 2008, and before that I was working as a solicitor in the UK. So I come from a sort of an English legal background. And what do notaires do, and how can we help clients purchasing the Alps? Well, a notaire is a similar role to a solicitor in the UK, a conveyancing solicitor, at least as far as property transactions are concerned. And our involvement is to ensure that the transfer of ownership of property is properly recorded, and that the clients are accompanied through that process and end up owning what they want to buy, and are alerted to any risks that may be associated with the ownership of the property. And we also get involved in assisting in structuring the transactions with the clients so that they can try and structure in a way that suits them best.
Okay, perfect. Thanks, Simon. And how does the French, being a French notaire differentiate from, say, for example, an English notary or British notary, should I say? What the main difference is?
Well, I mean, it's so the closest equivalent to a notaire in the UK to what a notaire does in France would be a conveyancing solicitor for this kind of transaction. And if you step back far enough, then the two systems are sort of the finality of the systems are the same in the sense that at the end of the day, the client ends up owning the property. The details very different between the two systems. And one of the key differences between the role of a solicitor and a notaire is that in France, it's possible for a notaire to act on behalf of both buyer and seller, which is not possible for a UK conveyancing solicitor. And we have a role, as well as part of our role anyway, is to ensure that we end up with a balanced contract, and that we're not there to try and skew the contract in favour of one client or another.
Makes sense. So am I right in thinking that someone can't buy a French home without using a notaire's services?
That's right. It's in order to record the transfer of ownership of a real property in France, then a notaire has to be involved in that, in publishing the agreement to the land registry equivalent.
Okay, perfect. And who can you represent? Who's your typical client? Who do you usually represent?
Well, I mean, short of certain people on blacklists, and there's not really anybody that we can't represent. But generally speaking, I mean, certainly personally, I'm often involved in representing non-resident purchasers or sellers, for that matter. And we tend to. One of the sort of things that we offer is being able to speak to clients in English, and so that they can help them overcome the language barrier. We represent clients all around the world, and not necessarily people whose first language is English, but people who don't speak French tend to have a second language of English, where we can sort of come in to help as well.
Okay, perfect. That aligns really well with SnowOnly clients. We've got clients from not just the UK, but all over the world. So really important that you're able to, one, speak French, which is helpful, right? Because not a lot of our clients actually speak French, but also
helpful and essential, yeah.
And when would you say is the right time for clients to, engage with you, speak to you?
Well, I mean, my preference is to try and have a contact as early on in the process, even if it's before the client's found the property that they want to buy, because it can be useful to have an early input to be able to give a bit of guidance as to things that clients should be thinking about when they're looking at a property, try and eliminate potential risks up front, or and sort of generally when the clients go in knowing what the process is that they're going to be going through, then it makes it a bit easier for them as they from the start onwards.
Yeah, for sure. That's a message that we try and drive here at SnowOnly as well. Is, do all your preparation and your research, and get all your expert contacts ready for when you're going out on your viewing trip or going starting looking at properties. It aligns well with what we try and say to clients here as well. So just run us through, I don't know, the legal process of buying in France. Maybe just
Sure. And effectively, there's a bit of a distinction to be made between an off-plan purchase when the building's not yet been built and the purchase of an existing property. Where it's an off-plan purchase, then the process in both cases is highly regulated, but it's different parts of the French legislation which apply. So an off-plan purchase, there's a two-stage process. The first is the signature of something called a reservation contract, which is a form of option which is given by the developer to the purchaser to buy the property. And that contract sets out the terms and conditions of the future sale and any preconditions which may need to be fulfilled on both the developer's side, and the developer has to have a host of different protections before the final purchase agreement can be entered into. And then on the purchaser side, potentially there could be a condition relating to the purchase of obtaining loan finance. And so that reservation contract is entered into, and then we go on, once all the conditions are fulfilled on both sides, we go on to the second stage of the process, which is the signature of the final purchase agreement, when part of the purchase price is payable. How much depends on what stage the building works have reached at the time the contract's entered into. And then as far as a classic purchase of an existing property is concerned, it's also a two-stage process. The first stage is a bit akin to an exchange of contracts in the UK, so that it's the thing whereby the seller's bound to sell. But one of the oddities of the French system is that the purchaser benefits from a 10-day cooling off period. So once that preliminary sale contract's signed, the copy is notified to the purchaser, and that starts the period running during which the purchaser could potentially decide to withdraw from the purchase. That 10-day cooling off period also applies if it's an off-plan purchase. And then, basically the main difference is that with an existing property, well, you know what you're buying, so there's all sorts of surveys which will be carried out in the property that you're buying, which don't exist if it's an off-plan purchase. And the purchase price in almost all cases is paid in full on the date of the signature of the final purchase agreement, rather than being stage payments like it would be an off-plan purchase.
Amazing, perfect, and that's a clear, the differentiation between off-plan and, we have clients that are looking at new build properties, but we also have clients that are looking to buy, resale chalets. So great that you differentiated the two for us. Speaking about off-plan, can you talk us a bit about GFA? What does that mean? We have a few clients that are going through that process at the moment. It would be great to get some clarity on that.
Yeah, so a GFA is something called a garantie financière d'achèvement, and effectively it's a guarantee that's provided by a third party who stands behind the developer. Most commonly it's a bank, and the role of the guarantor is to ensure that the building works will be completed. Even if the developer were to fail, the guarantor would have to bear the cost of appointing another constructor to finish off the building works. So it's a means of ensuring that the purchaser is never in a position where the building works aren't finished. And there is a second option within the within a GFA, which is that if for some reason it's not possible to finish the building works, then the guarantee is that the funds that the purchaser's already paid, the part of the purchase price that's already been paid, would be reimbursed to the purchaser.
Makes sense. Thanks for clarifying that. And how, again, might be a bit of a taboo subject, but how do you get paid? When do you get paid? How do your fees work?
Sure. First thing to say is for a property purchase, then the notaire's fees are fixed according to a tariff which is imposed by the French state. So there's no kind of discretion for us to set our own fees. The tariff is, for the most part, proportional to the purchase price. So the higher the price, the higher the fees would be. For an off-plan purchase, and in both cases, there's often a bit of a misnomer about when people talk about notaire's fees, because generally when they do, then they're talking about the overall legal costs of purchase, which include things like stamp duty equivalent and land registry fees. But to give you a rough idea, then if it's an off-plan purchase, then generally speaking, the percentage of the total purchase price is in the region of 2 to 2.5%, sometimes slightly less for higher value transactions. And for a pre-existing property, then it's in the region of 8 to 8.5%. And again, sometimes a bit lower for higher value transactions, just because there's, the fixed elements lead to an overall lower cost.
Makes sense. And those percentages, are they just your fees, or is that the total amount of fees on?
No, that's the total amount, which includes the registration taxes, so the stamp duty equivalent, and the land registry fees, and also disbursements.
Okay, perfect. And we have a lot of clients that are leveraging mortgages. I'd say probably about 50% of our clients are leveraging a French mortgage. So how does that tie in with your services? And what's the right thing for clients to do?
Well, but as far as that's concerned, I guess from a client's perspective, there are two options: either to take a loan out in their own country or to take a loan out in France. Generally speaking, if the loan's being taken out in France, then the bank will want to take a form of guarantee over the property that it's that the loan is going to be funding the purchase of, to ensure that if the loan is not repaid, that they've got security of something that they can call in to get paid out. And so in the cases where there's a guarantee, then the notaire would get involved in recording the loan agreement itself and recording the security being taken over the property and publishing it to the land registry. And in terms of what should a client do, I mean, I think the best advice I could give is if a client's looking to purchase, then it's a good idea to try and front end the loan application part of the process, to be in a sort of a really reasonably certain position that it is going to be possible to borrow, and how much it's going to be possible to borrow. Generally speaking, it's not always possible to get a loan offer, and in fact, most French banks won't issue a loan offer until the primary sale contract's entered into. But it is possible to start the process of an assessment of the criteria, whether the relevant lending criteria are going to be fulfilled, and having an idea of what information is going to need to be provided to start putting that together. And it's best to try and front end that.
Yeah, perfect. I know we're working with a client at the moment that you're in, using our mortgage broker to get the mortgage, obviously using your service as well for the legal side of things. I know you're in contact with the mortgage broker as well at the right time, which is important for the transaction to be going forward. So super useful information there. What happens if a client can't get a mortgage, for example? They've signed the reservation contract, come from the and then they can't get a mortgage approved. What happens in that scenario?
Well, for a client who needs to borrow to fund the purchase, then it's important to ensure that there's a loan condition in the reservation contract or the primary sale contract if it's an existing property, and that condition is there to protect the purchaser. And the condition will set out the characteristics of the loan that the purchaser is looking to obtain, so the amount, the duration, and the interest rate. And it will provide that if the purchaser applies for a loan on those terms and the loan application is refused, that they'll be able to, the conditions therefore not fulfilled, and they can walk away from the purchase and they can recover the deposit that they'll have paid already.
Okay, perfect. That's one thing I like about buying in France, is that the buyers are very protected when it comes to the transaction side of things, with cooling off periods, and like you said, if you don't get your mortgage approved, being able to walk away from the deal, etc. So I think that's a really good, and like you said before, even with mortgages, interest rates, etc. The buyers are really thought about when buying in France, which I really like. Different ownership structures. We've got some clients that obviously buy in as private individuals. Other clients are trying to buy through their UK companies, or other clients set up French companies. Would you be able to just tell us a little bit about the different sort of structures?
Yeah, I mean, we've mentioned some of the different options. A lot of clients buy directly in their own names, and there's nothing wrong with that. It's perfectly possible. And for some clients, there's not really a need to set up a company. And what I'd say is that if there's no need to do it, don't do it, because otherwise it's just creating a cost and it's kind of administrative burden, which doesn't really bring any particular benefit. For some clients, then there can be an interest in setting up a company, and there are various reasons why it could be useful, whether it's to ring fence the income that may be generated from the property in France, or to assist in or make it less costly to gift shares in the company rather than the underlying property in future, or potentially in relation to the tax treatment of income and capital gains in some cases that can there can be some benefits. If there's a question of which company and where, generally we tend to advise against using a UK or an overseas company to purchase a property situated in France, because there can potentially be some negative tax consequences of that in resale. Although some clients just don't have the option because that's where the money lies. In which case, there are things that can be done to try and slightly improve the tax treatment. And if it's a French company that's being set up, then there are, broadly speaking, two forms of company which could be relevant. There's one which is called a civil company, which is a bit like a partnership in English terms. So it's looked through to the shareholders when it comes to determining the tax treatment of the company. And then there's something called a commercial type company, and one that we see often is something called an SARL. And that one is can be sort of more appropriate for clients who are looking to buy a property with a view to letting out, but wanting to ring fence the income that they're receiving in France rather than having to report on it in their country of tax residence.
Perfect. Yeah, I think we've got a client that's buying with an ASLR at the moment, actually. So I know that is quite a common way of purchasing. This doesn't usually happen very often, as you know yourself. But what happens if a client doesn't go ahead with the deal? Like, how does that look?
Well, it depends the type of purchase, and it depends on the circumstances. So I mentioned the fact that there's a 10-day cooling off period. So, with clients who have changed their mind right at the outset, they've got that period of reflection to change their mind. And if they do, if they've already paid a deposit, then that would be returned to them. Clients who have got past that 10-day cooling off period, then there's the preconditions for completion that we just discussed. So, if that condition is not fulfilled, the client would be able to withdraw and would be able to recover the deposit, as long as they can prove that the reason the condition is not fulfilled isn't down to some kind of act or omission or negligence or bad faith on their part. And then for clients who where all conditions have been fulfilled and then they change their mind at the end of the process before completion, then again, depending on the nature of the purchase, the kind of potential penalty would be different. If it's an off-plan purchase, then the deposit is 5%, and it's 5% of the purchase price, and that 5% is the jeopardy that the client sort of potentially risks of deciding not to go ahead. And if it's a pre-existing building, then usually there's a penalty clause in the pre-sale agreement for an amount of 10%. So in the case of a pre-existing building, then it's a 10% that the client would risk losing. Okay,
that's good to know. Like I said, it doesn't happen very often, but good for for peace of mind, in case things can happen sometimes, right? Common mistakes. What was the biggest sort of, I don't know, I guess, pain point that you see with clients, or mistake that clients make when buying in France?
Well, I don't think clients often make mistakes, but the only thing, it's not really a mistake, but the advice I give is to just try and get in touch with sort of the appropriate advisors, including Notaire, at an early stage in the process, just so that it's possible to get the guidance and an explanation of what's going to be happening in the sort of further on in the process, to try and make sure that things are done at the right time and that things aren't missed at the start of the process, which then cause problems later on. So
yeah, that makes sense.
It's sometimes complicated for us if clients have already signed the preliminary sale contract and then they come and ask for advice, and there are things where we'd advise them to do something differently, and it's too late.
Yeah, that makes sense. We always find that if the client engages with us quite late in the process, they're sort of chasing the tail a little bit and playing catch up, and in some senses wishes they would have engaged with people like yourself and other experts 6 months before, sort of thing. So super important to get your ducks in a row for sure. Okay, last question. If you was to take one thing away from this video, what would you say is you might have answered this already, but what would you say is the most important thing from this video from today?
That's a difficult one. I mean, I suppose probably the answer I gave to the last question is just to to try and get in touch with us early on so that we can help guide through the process, because we can do our job better if we get involved earlier.
Makes sense. Perfect. Amazing. All right. Well, thank you very much for joining us today. For everyone that has stayed for this long 20 minutes, thank you very much for watching. Hopefully, Simon's answered some good questions really well, and really appreciate your expertise and your time on this. If you want to see more videos like this, do all my YouTube jazz, please like, subscribe. It really helps the channel. And hopefully see you on the next one. So if you're looking to buy in 2026, SnowOnly, obviously we're here to help you with your ski home purchases. But Simon can also, you work all across France as well, Simon, right? So if you are just buying a property in France, not necessarily a ski home, then you can still use Simon's services. I'll catch you everyone on the next one. Appreciate the time, and take care. Thanks, Simon.
Pleasure. Thank you. Bye.
Cheers.